likely to do so first. The second point is at 5170, at the top of the page, he called me out. That's Privy. We were in the room. He said he needs to talk to me in the jury room. I asked him what he wanted to talk to me about. He said to me that he knows that I'm influential and people listen to me. I said it's not about listening to me. It's based on whether I pointed them to the facts of what we hear, not to be influenced by what is outside. He said to me, well, he needs me to do him a favour. And then dropping down, I asked him what was that about. He said that we should go to lunch. I said, no, I can't leave because I have things to do and I have somebody coming to me. Basically, he said, I should convince everybody to release, and then, in answer to my Lady Simba's point, the men at the bar, not at the bar. And then over the page, 5171, judge asked the forewoman, you knew him before you came on the panel? No, I met him here. But when we met, that's when my suspicion of him grew. We started watching and observing his actions from there, although because initially he was mad. They chose me as the foreman. He went to everyone and tried to ask them to make him the foreman instead. And basically goes on to say, it's a duty, and we don't, being the foreman doesn't mean I'm going to have tea in the judge's chambers, eat crackers and go for lunch. It's a duty. So that's what she's saying. So what she's saying, essentially, is he seems to have gotten to the head that he wants to be the big chief. He's disgruntled about this, and she just took no notice. But importantly, towards the end of 5171, but over time he recognised that, okay, fine, before he started going to these persons and telling them that, listen, this is what we need to do. I would say, you are listening to the evidence. He said, no, we just need to let go de men again, them. So, when we speak today, he said to me, that's what we need to do. And he says she says the conversation went on for 5 minutes, so she repeats the £500,000 figure. Then towards the end of 5172, he says, as Mr. Southey rightly pointed out, Madam Foreman, 11 of us, he spoke to 11 of us, that would probably suggest, therefore, the discharged juror. He spoke to 9 persons first. The thing is, nobody's listening to him. Because nobody's listening to him, he wants me to speak to them. I do emphasise that. So I'm not listening to him either. That's the reason why I got him on tape. But the trouble was, the tape wasn't particularly clear, so it never got played. And then you'll see at Madam Foreman leaves at 2:52 p.m. Now, I emphasise that because she leaves in advance, and the summing up doesn't resume, I think I'm right in saying, until about 3:20. So there's plenty of time for her to inform, because she's bound to inform the jurors of what has happened, that she's been to see the judge in chambers. And you'll see 5173, the DPP says to the judge, I wonder if you can allow each team to discuss for 5 minutes. I will wish to speak, and I'm sure my learned friends will wish to speak, perhaps 5 minutes. So again, the reason I emphasise this is there's time for the appellants to speak to, or rather the appellants' counsel, to speak to the appellants themselves. And then the DPP, towards the foot of 5173, recommends to the judge, just warn them again about their oath, just their oath. That is what she is suggesting. And then over the page, Mr. Finson, Tavares Finson, you'll see 5174, the DPP at the top, repeats, as far as the prosecution is concerned, we're prepared for the matter to proceed. Just remind them of their oath. And then Mr. Palmer's counsel, we're of the view, don't see how you can proceed in these circumstances where you've got one person who is making an allegation that someone's going around offering the jurors money. She obviously has some tape, her role. So he seems to be objecting, not on the basis that, so to speak, there's a corrupt juror who is on their side, but rather, he's rather concerned about what the forewoman is saying. But in any event, Ms. Llewellyn then says, the DPP says, in fact, it's the prosecution who is most at disadvantage by carrying on. And in my submission, that's obviously right, in principle. There's one person who obviously wants to let these people off. There is a risk that he is going to be persuading others, or has persuaded others. And then you'll see at the end, at 5175, the matter ends at 3:07 p.m. And what happened immediately after that is when the summing up resumes, the first thing the judge does, I think I'm right in saying, is remind the jury, if I can just dig up my reference, I hope this is right, 5149 at 3:22 p.m.
Just remind me, Mr. Rogers was representing who?
I think it's St John.
Right, so you've got Mr. Finson not exactly agreeing with the
Finson's for Poplar.
Yes, I see. But you've got both Mr. Finson and then Mr. Rogers raising, on the face of it, objections.
Concerns. Yeah, no, I'm happy to accept that. They're saying they're not very happy about this. But I think one of the overcompensation point. And maybe Mr. Rogers says maybe there's a risk of overcompensation. But that is to say the jurors will swing too far in favour of the prosecution because of their knowledge of the bribery attempt. Can I just mention one point before I go to what the judge does? I should have made it before. It's not clear whether, and there was no investigation, whether or not the bribe was coming from the appellants themselves. And that's why I mentioned the figure of £2,700 equivalent. It may just be this particular person was, don't forget we're talking about very famous people, he's a particular aficionado, we don't know, of Mr. Palmer's and Mr. Campbell's work. But in my submission, what the judge has done, subject of course to the points of law, is in my submission, again, very difficult circumstances, but perfectly sensible. He's called in the relevant parties, and on the face of it, the party most affected by the problem, the prosecution, is saying, I'm prepared to carry on. And the reason, of course, for that is that this is day 56. In practice, it may well be very difficult to get a retrial of this matter. Another 56 days, we're going to have to get Mr. Chow to come along again. I would hope that we could take judicial notice of the sheer difficulty, certainly, in relation to some of these witnesses coming along again and arranging things. So on the face of it, it's the prosecution saying, I'm prepared to take this risk. And the first thing that then happens, going back to page 5149, is the judge reminding the jury at lines 3 to 13 of their duty.
He doesn't say there that they shouldn't hold anything against these appellants.
No, he doesn't. But my lady, I would submit is obviously implicit. I mean, the context here is that the foreman's been called over to see the judge to talk about the bribery, and she's been told to go back and tell the jurors to deal with the matter in accordance with their oath. And they, of course, will know about this, with these allegations of bribery, because it's said that the bribery has been offered to all of them.
So he can delegate his duty.
Well, my lady, my own friends like that. But no, I'm not saying he can delegate his duty, but it's quite clear that he's taken a favourable impression of the foreman, and it's quite a sensible way. He's not delegating, but he's saying to the foreman, you tell them, as you have been already, you decide in accordance with your oath, and then he reminds them of exactly the same thing when you get to 5149. I agree he doesn't mention, and my lady, my lords, one can see why. He doesn't specifically mention, I gather someone that has been bribing you. He's in a difficult position whichever way he goes. And I submit it's a perfectly fair thing to say, I'm reminding you of your oath. It's an oath that's signed according to the evidence. And the jurors would have known that was their obligation.
Sorry, which page were you on when you're saying that he immediately tells the jury?
5149. The summing up resumes at 3:22 p.m. 5149. So the first thing he does is tell the jurors after the break, which everyone knows what's going to be about. First thing he says, decide in accordance with your oath. In my submission, economy sometimes, just making the main point, is the best course. And this, in my submission, is a perfectly reasonable course for a judge to adopt, because everyone knows what he means by this. Can I just also emphasise that subsequently, at 5157, the judge repeats the direction he had already given But importantly, he repeats at 5157, decide the case against each of these defendants separately. That's 5157, lines 10 to 18. And he then goes on at 5159, he gives the sample direction about reasonable doubt. At 5159, at the invitation, I think I'm right in saying, of the Deputy PPP, who is back in the seat, so to speak, he gives good character directions at 5159. And I think those good character directions applied to all the defendants, bar one that may have been Mr. Jones, I'm not quite sure. Now, I mentioned the point about Shane Williams being acquitted. That in my submission is not an insignificant point. There are ECHR cases, which I don't have immediately to hand, but I'm sure I can find them in a minute, where problems have arisen, where the jurors have reported to the judge that one of their number is making racist comments. And there was one case, I will come to in a moment, where there were two defendants, and they were both Asian. And the report gets back to the judge. I'm very worried about this. This chap keeps on making racist comments. But the jury convict one, but acquit the other. The matter goes to appeal and say, well, there's no doubt there was reason to suspect bias, but on the other hand, the judge gave directions to follow the oath, and that went to the ECHR, who took the same point. And they said, well, the judge did what was necessary to remind the court of their oath, and you can take into account the fact that the jury did. They do seem to be able to distinguish between the guilty and the innocent. My lords, my lady, if I can, perhaps just have a moment, or if I can remind you of what that was in a moment. But I submit that is important. One cannot simply ignore the fact that the jury, on the face of it, have performed their duty. They've put this evidence. They've looked at the evidence and they've acquitted one person on whose behalf or in whose interest it was said this bribe was being offered. I think the name of the case is Gregory, but I don't have it. I don't have the reference to hand. So that's what I want to say about the facts. Then I come to the issues, if I may. I say there are two issues. The first is, was the judge obliged to discharge the jury? Did he have to? Did he have no real choice as a matter of law? The second issue is, if he was not obliged to discharge the jury, was the procedure he followed sufficient to ensure that all the defendants received a fair trial? Now, the first issue in my submission raises in turn two questions. The first is this. Was the judge obliged to discharge the jury on the basis that there was good reason to suppose that one of them was biased in favour of the defendants, or indeed all the defendants, regardless of the prosecution's willingness to continue? In other words, just as a matter of law, was the position such that, look, you haven't got 11 impartial jurors here. We know you've got one bent one, and he's bent in favour of the defence, but you have to discharge. And that's the first question as a matter of law. Notwithstanding the prosecution's waiver, if I can put it that way, of the point. That's question number one. And question number two is, was the judge obliged to discharge the jury on the basis that realistically the other 10 jurors, the non-bribing jurors, the other 10 jurors would consciously or unconsciously be prejudiced by their knowledge of the offers of bribes, prejudiced against all the defendants, regardless of the directions that he had given, or indeed could give, to tell them to abide by their oath. The other my submission is a separate question.
There is put in public, there's a real risk that they might have become consciously or unconsciously prejudiced.
Real risk they might have become. That's why, forgive me, my lord, that was I was trying to go by the Putnam test, consciously or unconsciously. Is that something which was going to be in the back of their minds? Come what may. Now, on the first question, namely you've got one rotten apple here, so that's it. We say that can't be right. We have in our case drawn attention to the case of Brown, which is in the electronic bundle at 6329, paragraph 31, where not identical thing happened, but the problem arose, what is the judge to do? Or rather, the point was made.